Wonderful, thank you. It is such an honor to be here today. My colleagues were very jealous when I told them I was invited to speak at your conference here on the digital asset revolution. One thing about Americans is that we love the word revolution. We still talk about our revolution against the British Empire, and we sell things with revolution. You would be surprised how many times you see something that's revolutionary or some kind of word of revolution for our products of makeup. It's the makeup revolution, or beer, or financial advice, or movies, cookware, protein powder. All of these things you will find the word revolution by. And so I think that this is a apt word for the digital asset revolution. First, it got my interest. And second, it really has changed our lives and the way that we treat property, both during our lives and then at our death. And so today I'm happy to speak about this topic, which has been near and dear to my heart and my research for the last decade as I've been a law professor in the United States of America. I want to tell the story regarding digital assets after death because it was a surprising topic that took all of these companies by surprise when they realized that their users would eventually die. And the story is encompassed in this idea of the development of digital assets and how now, about 20 years later, the law has addressed it and not addressed it, how the companies have filled in the gaps. So I want to tell that story. I want to talk about the current legal framework in the United States, and then the problems that come up with this regarding privacy, especially after death. So I use the term digital assets broadly, and I've somewhat categorized them in my work. The first kind of digital asset I want to consider are our social media accounts. All of the documents and pictures and information you have stored about yourself, about your family on those websites. So take a minute and think about your LinkedIn profile. All of that information documents those pictures. The second I want to talk about are the value, the assets that have value. So think about not only cryptocurrency, which I think has taken a bigger role, obviously, in this discussion, but even reward miles or money that you have saved on PayPal or eBay. All of those credit card rewards, et cetera, that have value that people may want to transfer upon their death. And then third, which has become, I think, less significant, are our digital media and resources. So the music that we've purchased, the books, the videos, et cetera. All of that media that we have stored electronically that never was stored electronically before. And so the law treats these assets differently, but I do want to start here with our first category of social media accounts because I think that's what tells the story of how digital assets became a discussion of what would happen to them at death. So, it has been a good 20 years that we've had these digital assets in our lives. The first occurrence really was America Online that became very popular with 9 million subscribers in 1997. It started operations in 1993. More familiarly, Facebook now started in 2004, and it spread to other universities in 2005. Gmail launched in 2004 and added a panoply of services, including photos, document storages, maps, videos that we have today. It acquired YouTube in 2006 and, of course, continues to offer a platform to create more and more digital assets as we go on. So without a doubt, these online service providers have facilitated the creation of a new form of property. We have not seen this kind of property before, although many of these digital assets are firmly rooted in history with paper and other tangible equivalents. And so this transformation from the tangible to the digital has caused a need for legislative reform, which, at least in the United States, has been slow in coming. One thing that I know from my research and anecdotal encounters with employees of Facebook, of Google, as I've talked to them over the years, is that death was the furthest thing from their mind when they established these companies. They never thought about it. Facebook is a good example. It was established 20 years ago this next year. As we know from this history here, it was created by a 19-year-old and was traditionally thought of to be a dating platform. Right? He wanted to date other other Harvard students with their picture posted on this Facebook. So certainly the origin of that as a dating platform was never considered to think, well, what happens if this user dies? Because the limited use was only for occasional meeting, romance, hookups. Now, it's estimated that close to 30 million Facebook users or accounts belong to dead people 20 years later, right? Because it has spread in popularity. So experts estimate that if Facebook remains at its current levels, which is a big if, at some point it will house more dead people's content than actual living users. Now, I use Facebook as an example, but clearly the implications extend to a vast number of digital assets that people own, and that nearly every person in the world has accumulated at this point. It's not clear what people's digital presence will look like in the future. Who knows? We'll laugh in 15 years that we were even still talking about Facebook. But we know that an increasing number of people will have some kind of digital presence in the future, in the years to come. And the treatment of these assets, I think, will be an even more pressing issue as history unfolds. Several years ago, the Harvard Magazine estimated that just in the past 2 years, and this is what it says in 2014, in 2 years, computers and servers have accumulated more data in those 2 years than the whole record of human civilization. And so this superabundance of data and information about each person raises serious concerns that I hope we address today and that the law will continually need to address as we go on. So the inheritance of this information, of these assets, is a really important issue, both for today and for the future, for the individual and for society. So the story that begins this issue happened in 2005. So again, relatively recent after the development of widespread usage of email and social media. This takes us to Michigan, where a father lost his son in the American war in Iraq. And he went to take the son's assets, which under American law would all go to him as the parent. The son did not leave any kind of testamentary instrument, a will, or a trust. So under American law, the father had the legal right to the son's assets. Now, he wanted the Yahoo account that his son owned because it had a treasure trove of information about his son, his correspondence, his pictures, documents that would help the father mourn and take his son's memory into the future. And the father contacted Yahoo about obtaining access to his son's account as an asset of the estate, and Yahoo flat out refused the request. It pointed the father here to its current contractual language that we all have agreed to if we have a Yahoo account as we clicked to access the service. And the clear terms of the agreement said, once you, upon the receipt of a copy of a death certificate, your account may be terminated and all contents therein permanently deleted. So this gives wide latitude to Yahoo. It does not need to transfer the assets to the family members. Instead, it will perhaps terminate and perhaps delete, but it seems to be much more in the purview of Yahoo. Well, this was unimaginable at the time for the father, for what the public expected. And so the father took Yahoo to court in Michigan and forced a judgment about his property rights to his son's email account. The probate court did order Yahoo to give the contents of the email account to the soldier's father. And this story was well reported in the news, and public sympathies were definitely on the behalf of the soldier's father. Similar cases began percolating through the American courts. Families were seeking answers after their loved ones died. A woman died falling from an apartment building, but the family thought it could be homicide and wanted access to her digital assets to verify. A young man was killed in a motorcycle accident, and his mother wanted access to his social media. In Virginia, a particularly poignant case occurred where a teenager killed himself, and the family wanted answers. Why? How did he feel this way? What had happened? To find clues about what had driven him to suicide. The family successfully lobbied Virginia's legislature to pass a law when the social media accounts resoundingly said, no, 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 we're not going to give anything. And so these cases, the loss of these cases in the courts spurred the legislators to act, to pass legislation to protect the rights of the family to acquire digital assets of the deceased. In the United States, property is a matter, succession law is controlled by the decedent's intent. And that's the cardinal rule in testamentary construction. It's always been that the decedent gets to control their property. There are some statutory rights for a spouse of a decedent, but other than that, which is unique in succession law, worldwide, American law gives the right of the dead person to control their property fully. And so this was the expectation for what would apply to digital assets as well. Now, each of the 50 states in the United States can make its own law about this. There's no national legislation because as property law, it's seen to be in the purview of each state. It's not a federal issue. And so here, in the aftermath of these cases, only 8 states acted. But all 8 states that passed legislation on the matter said that it should belong to the family if the decedent has done nothing, right? The default is that we'll treat it like every other piece of property, and it will transfer to the family to make the decision about what to do with the digital assets. So this followed the long tradition in American law to give the right to the family to dispose of these assets as they saw fit, as opposed to the private companies. The law rejected the notion that private companies could impose, like Yahoo did, this non-inheritability clause in the terms and service agreement and digital assets. That was only 8 states. The majority of these states kept the law unsettled. The right to digital assets after the decedent's death was still controlled by the companies, by the terms of service agreement that the parties entered into when they began the use of the service. These adhesion contracts we're all familiar with. We click through in order to get to the website that we want or the service that we desire. So by signing up for the account to create digital content, users really signed away their rights to their digital assets under the law. And in most of the states, the states hadn't responded. So an organization that's devoted to uniform law in the United States came together with academics and practitioners to try to develop a law that could be adopted in all 50 states. The commission proposed a statute that adhered to the traditional understanding of the law, like I have spoken about, that the 8 states had enacted. And that the holding there would be that the digital assets would automatically transfer to the decedent's heirs. And when the commission moved forward with this proposal to the 50 states that were involved, it received intense feedback and lobbying against it from the industry. So companies like Google and Apple and Facebook sent their lobbyists to the Uniform Law Commission and made it very clear that it would be an uphill battle to get this legislation passed in all 50 states. The commission worked with the companies and compromised, proposing new legislation where the default was flipped. The default rule then would be that digital assets would remain in control of the companies unless the decedent specifically authorized the heirs to inherit the property. And again, that's a huge flip from the traditional use of inheritance law in the United States. This law went through like wildfire. Most states adopted it relatively quickly, and then under the guise that this would allow these digital assets to be inheritable if the decedent intended them to be in a testamentary document, it got the support of the state legislatures. However, what this means is that most people, over half of the people in America, don't write a will. They don't enter into a trust or any kind of testamentary document. And so for the majority of Americans, companies will control the digital assets going forward after their death. Recently, in 2019, one of the first cases was brought under this new law that was passed in most of the states. A university student died on Christmas Day in his sleep. The autopsy report was inconclusive, and the student's parents desperately wanted access to his digital asset sites and his iPhone to understand what could have possibly happened to their son. The son died without a will. He was a young guy, didn't think that he needed any kind of testamentary document. And so under the law, the parents didn't have access to his digital assets. They took it to court with this argument that the death was inconclusive, they needed access, but the law is very clear. They could not access the digital assets unless the son gave explicit permission in a legal document. He had failed to do so, and so the company retained access and control over the deceased user's digital assets. Apple refused to give his parents access, and the court upheld Apple's right to do so under the digital asset law. So I think this kind of law gives way too much control and power over digital assets. That power could easily be abused in the future, and it's giving what has traditionally been the court's role to determine the fairness of the issue back to companies to make those determinations. Now, to their credit, companies do involve boards and committees to make these determinations. It's not always just a flat out no, but the expense of doing so makes it less likely that the company does and will give access to digital assets. So this brings me to the second big issue I wanted to talk about today, and that's how posthumous privacy rights regarding our digital assets then are handled. If the companies have control over this, and the contracts that individuals enter into when they sign up for digital assets prohibit the transfer as a default rule from the property for being transferred to the family, that puts the companies in control of a large amount of data and information about us all after our death. Now, companies, again, usually justify their refusal to transfer these assets based on the laudable goal of privacy. And I'm sure that all of us can think in our digital assets, in our information on the cloud, some things that we do want to keep from public disclosure or even disclosure to our family. So that's not entirely out of the realm of reality that some people would want these assets deleted or terminated, if you will, upon their death. In America, privacy interests are not protected at death. And so in the end, I think that this gives the companies even more control over decedents' digital assets than they should have, because there's no contrary protection of privacy rights once you die. So, in this idea of privacy, one of the aspects here is that when an individual dies, their will is probated in open court. And this has resulted in a lot of drama about the secrecies that someone's will reveals. There's a TV show that's devoted to finding out how these secrets have been revealed in the law. And so, well-informed individuals know that in order to protect their privacy after death, they need to have some kind of trust or delete these assets before they die. So I think with the problems here of privacy after death, we need to consider what options the law has in order to deal with this. The first, and the situation that's happening now, right now, is that companies will have the discretion to determine what happens to our assets. And we know that that may not be what's in the best interest of society at large. There is a historical aspect here that's important, right? So this is a great story that came out of in The Guardian several years ago. This chest of letters was discovered from the 17th century society and really helped historians understand what was happening. These are our digital assets today, and the chest will be in the Google and Amazon and Apple vaults. And so the law really does need to consider what's going to happen. The last thing I want to talk about is how companies have been responsible, even though there is no law to require certain actions of them to retain privacy. So, for example, Google, Facebook, and Microsoft all have clear policies that you own what you own and that we don't claim ownership over it. In practice, we can see that they still can do what they want. Google, for example, gives us an option to make our testamentary intent clear in the product itself. But the problem is that companies change their minds, and Delta is a good example of this. In 2013, they updated their policy where their reward miles were transferable at death, and then they ultimately decided that they were not, right? Because the company can make these decisions at any time. And so again, this is just an important piece of the digital asset revolution to consider that these assets are in control of the company right now, that privacy after death, although there is more protection in Europe, Europe's ahead of us with the right to be forgotten, has not solidified what's going to happen to our digital presence after death. And it becomes incumbent upon the law to make a change here, because after the revolution of digital assets has occurred and everything has become digital, there's still very little attention to what the long-term effects of that are after death. So I hope to continue this in the question and answer session. Thank you very much.
And at the beginning, I would just add that we are, of course, lawyers, but we are, together with Professor, we are connected with medical law, because Professor is plenipotentiary of the Marshal of the Western Pomeranian Voivodeship for organization and management in healthcare. And I, as a legal advisor, I'm also connected with medical and health law, and I'm also judging in such medical events commission. So we have also the experience from the other side, how dangerous is this digitalization and having data assets in medicine, because it's for sure we can say that today law is in medicine and medicine is in law. So these are these two topics which need to cooperate, and we should cooperate with medical professionals. And healthcare organization is, I think, a necessary condition for building a modern and patient-friendly healthcare system. We all were, probably we will be a patient, so we need also to know how to use these data assets, how they should be used in medicine. But also, I think that we need to show this possibility of using data that are involved in a lot of databases. We will share our Polish experience, and at the beginning I will just say, as Professor mentioned, that the e-health centers, its flagship product in the e-health system in Poland, which forms the basis of a digital ecosystem of all medical services. Our Polish portfolio, if I can say like this, includes IT system, medical records, business analysis, and also cybersecurity services. And their purpose is to enable secure access to medical information for patients, this data, this digital access, and also medical professionals and public administration. So this our Centrum e-Zdrowia, it's called like this center, e-health center. It's the main place there where lawyers are cooperating with medical professionals, but not always this cooperation is successful, because you know that our legal language is not for people who are not involved in legal system and who are not lawyers. So this is very difficult to say to the medical professionals that you need to protect data. This digitalization in Poland, it started basically 20 years ago in 2003, when we had first working on the national e-health system. This process of digitalization, of creating data access in e-health care and creating e-health care system began at the end of 90s, and in this 2003 we started working on the national, as I said, e-health system, a central information system designed to integrate the various components of health care information. Then a little bit later, 2011, we had first prescription pilot projects, but still that were a project, because the most important years was, I don't know, last 4 years, when we effectively are using now this all things that we were talking about at the beginning. A sick leave, a patient card, a referral system, and electronic medical records. I will talk a little bit later about this, because this was a little bit crazy situation, because our legislator provides a legal act on electronic medical records in 2011, but in fact it started working in 2019. So we had, prepared all regulations, but the reality wasn't cooperation with legislator, and that shows also that this is not so easy, because even if we have prepared programs, if we have prepared these digital assets and all things, it's not able. We are not always able to use it. In meantime, we had 2018, and it was very important year because of implementation of GDPR. In Poland, we were crazy about GDPR, in spite of the fact that we had very good legal act from '97, which was held to data protection, but this was also the year that even we had something prepared, some solutions, we needed to change this. And what's dangerous in this digital assets in medical care is that still the Ministry of Health is the administrator of the data that are involved in all things that we are using. We have we used a lot of reports, lot of strategies and so on. But the basis, the most important is legal act on the information system in health. But as I said, as you can see, it's dated on 2011. But in general, it was. This is the last version. Is not that it was at the beginning. So we have now, I don't know which version of this legal act, but finally I hope it's working, and finally we can use these all things that were prepared in a health system, as I said, as the foundation of a digital ecosystem of medical services. This system is made up of two things: digital services, prescriptions, referral, EDR, electronic medical records, and also a solution that streamline the processes of planning and implementing also healthcare services. The aim was very simple. It was just increase the quality and efficiency of healthcare services and support the daily work of medical entities. What I'm afraid about is that still we have people who are excluded in this digital way. So this is. For us, I think this is very helpful, but we also should think about those people who don't have access to the internet. still this is happening, who don't have the possibility of using these solutions, because even we have very perfect prepared and well prepared solutions, and we are using these digital resolutions, we should remember that we are not the only one who is using this. And the second thing is data protection. I'm a huge fan, and I'm also, as a legal advisor, I'm using these regulations, and I'm implementing the documentation and solutions. So this is the second point that we should focus on, not only in medical healthcare system, but general, where we are using this digital assessment. Also the aim and enabling the collection, processing, and sharing of digital resources on patients, medical events, and electronic medical records indexes. The system, our Polish system, covers all medical entities, regardless of the source of funding for the services provided in them. We had two project phases. As you can see, the total amount was very big of this project. First part was from 2017 till 2015, and it included the design and manufacture of products. Second part and second phase was from 2016 to 2022, included this GDPR time, but it was very important because this second phase included the production of the remaining products, administrative subsystems, and service bus, the integration with phase one products and implementation. But could we realize that something what we were talking about in this first phase, should it be integrated with the products that were creating in the second phase? So the time, I know that 2 or 3 years we can think that it's not a long time. But I'm not technical person, but from the technical side and point of view, I think that this is, not possible to make this in a very coherent way. That's why this creating of effective e-health system was so long, because each year we had something new that we needed to include also in this legislatory way, not only in the technical one, but also in this legislatory way. What I would like to show you, this development of e-health in Poland includes a lot of products. I know that the time is limited, so I will just talk about the main things that we are using now, because of course one of the main objectives of the European Union is to develop an economy based on modern information technologies. That's why we are seeing each other in person here. But this also applies to healthcare, where the use of modern solutions increases the efficiency of healthcare. So the process of informatization, of digitalization in Poland included at the beginning using of electronic platform for electronic services. It's called like a PUAP in Poland, and it was the first platform that we were using to this electronic communication with other organizations, with also organization. I can say like this, to have contact from patients, and they can register it, and they could also access their medical data and use various healthcare related services. But it was the underground. It was the base of the later activities that were made. Second thing was maybe the last, electronic medical records. As I said, the legislation were prepared in 2011. Finally, from 2019, I can say in the main way we are using this, and we are creating these electronic medical records, and it was a part of the computerization process in general. These medical facilities, such as hospitals, clinics, and outpatients also clinics, were implementing electronic medical record systems that allowed them to store, share, and manage patient data electronically. But this with this is connected a very big risk about data protection. 2 or 3 months ago, I got the information via short message on my phone that the hospital where I was a patient have some problem because the patient's data were given to somewhere else. So the reaction was very fast, but it shows that these are only technical solutions, but we need to have and to think about cybersecurity also, and about these all things that provides us to think about data protection and to keeping them in a safe way. Also, we have electronic prescriptions, we have electronic sick leave. These are very modern way and modern solutions that patient is not able to go to employer and to give this sick leave, but it's making completely automatically. And having some more detailed information about 4 things. Electronic prescription is an electronic document that has replaced the traditional paper prescription. But this is not a rule that all people should have a phone or should have access to the email, because, as I said, we still have people who are excluded in this cyber way. So this is one of the possibility, but it means that we would like, of course, it to be rule, but we should have this other solutions. But this is really comfortable for patients, because when I'm going out from the doctor, I'm just giving SMS with the code or with information that you have prescription and you can buy these pills, because you will receive a free SMS on an email from the eHealth system only if we have logged to the internet patient account. The main thing is this internet patient account where we have all information about us as a patient. It's available on the website, but we also have this mobile application. So the access is for those who are using it effectively. It's very, very simple. As a rule, a prescription is valid for 30 days, but it doesn't mean that after that time it's cancellating from the system. No. It is still in the system. The information about the pills, the medicaments that we were used to buy are still in the system. So you can see that this no limited information are still so. We gathered more and more data information about the patient. The second thing is a sick leave application. As I said, that sick leave in electronic form. This is very comfortable for patients, for employees, and for employers also, because as a result, the patient doesn't have to provide the exemption to the employer if he or she is an employee, or to the social insurance institution if he or she is self-employed. So since January 2016, this was implemented, and doctors have been able to issue electronic sick leave called ZLA straight to the employee or to this service. And the third thing is a referral. January 2021, since from this time we have referrals which are issued also electronically. So all referrals are available still, again, to this internet patient account and in application. So the advantages of this are very big, but also the risk about this, it's being visible. How it looks in, because I can see that I don't have much more time. How this look in how this look in numbers. 17 million of the internet patient account. 17 million patients uses this internet account, which is I think a huge number of data that are based in this account, because this all informations about us, all informations about our health, about our history of health. 1.7 million prescriptions issued, 1 million API application installations. So from those 17 million people who are using internet patient account, 5.1 million people has the application in their phone. We know what we are doing with our phones and how big risk is to get the access to the information for the third person. And 155 million referrals issued. As you can see, the numbers are very big, and I think that talking about digital assessment in medical healthcare, we need to focus on management of this information, of this digital assessment, about the data protection, and about cooperation, lawyers with medicials, which, as I can know, is not always a very simple one. Thank you so much for the attention. We will share the presentation if you would like to have it. Thank you so much.
Thank you so much for having me. It's really a great pleasure for me to be here. That's both professionally and personally. Professionally, of course, because this is such a hugely important topic. There's a very impressive list of speakers, and I'm very proud that I can be here on this important conference. Also personally, because this is my first time in Vilnius, and I have to confess, without Vilnius I would probably not exist. Why is that? It was here that my great-grandfather was studying. He was from Poland originally. He was studying here, and it was here that he was promised to marry my great-grandmother. So this is here because this was such an important center of learning, that my great-grandfather was studying here, and that's where they met. And of course, if that would not have happened, I wouldn't be here. So also from a very personal level, I'm very grateful that I can speak to you today. But, ladies and gentlemen, the topic is a little bit less romantic, because this picture you probably all recognize. This is Sam Bankman-Fried, the CEO of FTX. His trial started last week, and you know, this will center around some $8 billion that was that's lost of client money, and this is what will be one of the most important topics of this trial. And this is also the topic, the challenge, because that's one of the that's the name of this conference. Of course, one of the challenges I think in this digital age is how to best store and to safeguard client money and client assets, and that's the topic that I want to talk to you about today. Now, what is the basic problem here? The basic problem is about custody, and also thinking from a legal perspective, we have to go back to the fundamentals, right? So what is custody fundamentally? I think this is two things. First is that the asset must be kept or administered by the custodian. So the custodian has a legal obligation to safeguard the asset, but the property interest, the ownership, if you like, remains with the client. So those are the two elementary functions of custody in general. And we find this already in Roman law. Maybe here my background in Greek and Latin comes back. But so this is really also what the Romans formulated. Was a real contract, in the sense that although it was a contract, property remains with the one who gives the asset in custody. We see it also, this elementary contract, we see this in the common law, we see it in the civil law. In many civil law jurisdictions, it is a named contract. We have special provisions for it in the civil code, in the Dutch civil code, probably also in the Lithuanian civil code, you have special provisions for custody. We see that around the world. But this is all fine until we get to the point where interchangeable assets are being kept in custody by the custodian. Sometimes they are called fungible assets, right? And the problem is commingling. So when the custodian holds in custody assets from clients that are interchangeable, then commingling becomes a really big problem from a legal standpoint. Because what happens is that if the assets become commingled, the clients cannot identify which exactly assets are theirs, and that means that they lose ownership, or at least that they cannot assert their right of ownership, especially if the custodian falls insolvent. Because then in the insolvency, the liquidator will say, if you want to revindicate your asset, you have to identify which asset is actually yours. And if you cannot do that, then I'm very sorry, but the assets are then part of the estate that can be liquidated for the benefit of all creditors of the insolvent custodian. And we've seen this in insolvencies, in bankruptcies around the world, certainly also in the Netherlands in the 70s. A very venerable old bank fell insolvent, and this is exactly what happened. Two investors who knew that they had certificated shares, securities, deposited with the bank, they could not retrieve it because they could not identify which of the 4 papers that were actually there in the vaults of the bank were theirs, because they were interchangeable. So this is a big legal challenge, and jurisdictions around the world have addressed it and have come up with different solutions. And I think if you look at all those solutions, they boil down to one thing, and that is asset segregation. So asset segregation is the technique by which the assets of the client will be segregated from the assets of the custodian itself, so that the assets of the client do not become available for the creditors of the custodian. Now, how to achieve asset segregation? That's not so easy, because in many jurisdictions, especially civil law jurisdictions such as my own, it is not allowed to partition an estate, because under our laws, the entire estate of a person should be available for claims of creditors. So there has to be different, also statutory ways to achieve this. Under the common law, it's a little bit easier to achieve, and that's because they have this flexible instrument of trust, which I understand does and does not exist under Lithuanian law, but and under common law, it's a common technique to create a separate estate. Under civil law, most often you need a statutory intervention to create a pool of co-ownership, which in many jurisdictions has been done for the custody of securities, for instance, or the creation of a special purpose vehicle that is specifically dedicated for the custody of client assets. Now, all this also applies to digital assets. Not all of them. I think medical records or Facebook data, probably they are not interchangeable because they are linked to one person. But when we think about financial data or financial digital assets, then probably and most likely this very same intermingling issue is relevant. And we have seen that in bankruptcies of digital asset custodians around the world. The first example, a notable example, is Mt. Gox I think it was then the largest custodian of Bitcoin in the world, a Japanese one. It fell insolvent, and then the court had to decide the difficult question of how to assess the claims of the clients, and then, of course, whether they could retrieve the Bitcoins that were stored and administered by Mt. Gox. Now, I will not go into the details of the qualification of the asset. That is something that my colleague Professor van Erp will say more about after me. But the interesting here is that the court, the Japanese court, said claims of clients are not property law claims. It is a mere contractual claim that they have against the estate, and that of course meant that they received very little, if not nothing, in the liquidation and the distribution of assets. A couple of years later, there was yet again an insolvency of a crypto exchange, this time an Italian one, BitGrail, and the Italian court took a very different route. It did qualify the assets as property law assets or property assets, but it held that these assets were commingled, and so because the exchange was considered to be the holder and therefore owner of the asset, the clients could not identify which digital assets exactly were theirs. So also here the end result was that they did not receive anything out of this insolvent estate. So although Japan and Italy both are civil law jurisdictions, the courts found very different ways to address the same problem. Then Cryptopia, a couple of years later, a New Zealand, a digital asset crypto exchange in New Zealand fell insolvent, and there the court found yet another technique, namely it applied the trust. And here this was better news for the clients, because in that way the client assets were segregated from the assets of the estate of the crypto exchange itself. Although within the trust there was commingling, the court found, but at least this was better news for the clients of this crypto exchange. Now, what will happen in FTX? Nobody really knows. We have to see and wait what I think it's the Miami bankruptcy court that has to decide on this. We will have to wait and see. Now, this of course paints a rather grim picture, these various solutions that we see around the world, and certainly not all of them eventually to the benefit of clients. So international organizations have implemented and found new ways to tackle exactly this issue. And I want to show you at least two of these international initiatives. The first one is an EU regulation, which you are probably familiar with, the Markets in Crypto Assets regulation, which was adopted only a couple of months ago. And this regulation is mainly an administrative law regulation. So it's mainly about the supervision of crypto asset service providers. When they do something wrong, then they can be fined, or when they want to start their service, they need a license. All those typically administrative law stuff you can find in there, but it also contains one or two private law provisions, and they are, well, at least from a Dutch perspective, not always very straightforward, because it says here in Article 70, paragraph 1, crypto asset service providers that hold crypto assets belonging to clients or the means of access to such crypto assets shall make adequate arrangements. Here we have the adequate arrangements, so the very first element of custody that I showed you in the beginning, but adequate arrangement to safeguard, and then here it comes, the ownership rights of clients especially in the event of crypto asset service providers insolvency, and to prevent the use of a client crypto assets on own account, except with the client's express consent. So two elements here. These crypto service providers need to preserve ownership rights, which is interesting because, at least under Dutch law, you cannot have ownership technically of digital assets. But here we have a directly working European regulation that says you can. And secondly, there is this prevention of the use of client money. Well, this, of course, would have, if this would have been in the FTX situation, would have been a current law and also have been applied, then probably it would have saved all these clients a lot of money. But I want to focus now on the first part of this. Because something similar, but I think more functional and more adaptable to other jurisdictions, has been done in UNIDRA instrument that has been officially launched only last week. I was involved in the drafting of this instrument, and there also important provisions are included that exactly address this issue of custody. So a very important principle is to be found in Principle 3, where it says that a digital asset can be the subject of proprietary rights. So this addresses this problem that the Japanese court had when finding that clients only had a claim, a contractual claim against the custodian. So that this principle really makes clear that jurisdictions should make their law so that clients have proprietary rights. Which proprietary rights exactly? That is left for the national laws themselves. And then we go on to Principle 13, which says that if a custodian enters into an insolvency-related proceeding, a digital asset that it maintains for a client under a custody agreement does not form part of that custodian's assets available for distribution to its creditors. So it's really the end result that should be achieved, namely that client assets should not be available for the creditors of the custodian itself. So this implies that in some form of asset segregation must be achieved. So again, in the when zooming in a little bit more on the UNIDRA principles, the main obligations of the custodian are spelled out also in, and that is in Principle 11. And it's also stated in the very beginning, where we have a more general section on core concepts, where it says that the digital assets maintained by a custodian for clients are not part of the custodian's assets available for distribution to its creditors if the custodian enters into an insolvency-related proceeding. So this is, in other words, the principle that I've just shown you. But the question then is, of course, how this should be achieved. And as I said, this is an international instrument where we did not want to prescribe a specific legal technique. We thought it best to leave that to the national laws itself, so that it could be suited to the legal tradition of the national systems themselves. But the functional result, that should be very, very clear. There are namely, and the result can be achieved within the context and the structure of the UNIDRA principles in two ways. The first one is by organizing it so that there is not custody in a strict sense, so that the clients remain owner and also remain in control, as we define it, of the digital asset. So the intermediary, the organization that maybe manages the app through which you can access your digital assets, or that organizes the exchange, legally is not in control, so that the client has a direct claim and retains a direct claim against the digital asset itself. And this is also what has been chosen in, for instance, a very recent initiative by the national banks of Israel and Hong Kong, where these central banks are finding ways to issue digital currencies. Also, the European Central Bank is very well advanced in the development of the issuance of digital currencies. And in this very recent initiative by the central banks of Israel and Hong Kong, they chose exactly this route so that the ultimate clients, the ones who have these digital currencies, have a direct link with the property, and the intermediaries, the banks that will probably administer this, they do not have control. They are only, and they are called in that specific initiative, they are called access enablers. So through this, there is no problem with commingling and the assets becoming part of the estate of the custodian. The second route, where there is custody in the sense as I just discussed it, then there should be legal segregation, not only in insolvency, that is this principle 13, paragraph 2 that I had on the previous slide, also outside of insolvency, and also when the custodian has engaged a sub-custodian, when there is multiple layers of custody. Also there, if the first custodian goes insolvent, then the client should have a right against the sub-custodian. There should also not be commingling in that situation. Now, as I said before, how to really and then factually achieve this legal segregation, that is left to other law. That could be done in various ways. For instance, in civil law jurisdictions, you could think of the codification into the law of this principle, as I had it on the slide, to have an actual rule that says that. That might be accomplished through the creation of a pool of assets, of co-ownership, where the clients will be co-owners of this pool, which then does not form part of the estate of the custodian itself. That is a possibility. Then under common law, as I understand, if there is operational segregation, so if you require the custodian to administer very precisely which assets belong to which clients, then through that operational segregation, by that operational means, that also implies a trust. That is at least also what the New Zealand court found. And then through this operational obligation, you can achieve legal segregation, but that is not the case in many civil law jurisdictions, at least not in my own. And then there are other ways, may also be possible to achieve it, for instance, by creating this special purpose vehicle. So it's a corporate law route you could think of, under which the asset clients will be held by a special purpose vehicle. Now, where does this all lead us, ladies and gentlemen? I think the most important starting point would be that digital assets can and should be the subject of proprietary rights, of property law rights, which is not evident because in my own jurisdiction only a couple of months ago the Netherlands Commercial Court found this, namely, although it may be desirable in this digital day and age to apply the concept of ownership analogously to digital data, this would be contrary to the closed system of Dutch property law and encroach on the domain and prerogatives of the legislative branch. So the court did not find itself at liberty to say clients can have ownership rights of digital data. I think this is something that should be addressed. Now, also for most jurisdictions, if we want to have proper legal protection for investors in digital assets, if we want to really respond to their, I think, justified expectations that if the custodian falls insolvent, they can retrieve their assets. For that result to be achieved, we will probably need to amend our laws. I think that's not sufficient. It is necessary but not sufficient. We also need some administrative law modernization. We need proper supervision, such as has now been adopted through the EU marketing crypto assets regulation, where we now have this rule, for instance, that custodians may not use client assets without their express consent. I think those type of rules should really go hand in hand to achieve a proper protection of investors and clients. And what is interesting to note here is that transnational instruments, such as the one of UNIDROIT that I showed you, but also a new initiative by the Hague Convention on International Private Law, together with UNIDROIT, they take the lead in this development. Ladies and gentlemen, that is what I had to say. Thank you very much for your attention.
Dear organizers, ladies and gentlemen, it's a pleasure being here again. I was here many, many years ago after communist went, and I was involved in projects concerning drafting the civil codes of the Baltic states, among others. So it's a real pleasure being here. In a way, it's also good that I'm the last speaker for this panel. First of all, we had a discussion on data ownership and inheritance. In fact, I was observer at the ULC during the discussions on that particular model law, and I've seen the letters by the tech industry, and they were quite threatening to the ULC, so they had no option. Whether the end result is good or bad is something else. About health data, in the middle of the COVID crisis, I wanted to know, what about the data in my COVID-19 health app? Are they my data? Are they about my body, my health? But when they are uploaded to a government computer, what happens? That's the problem you talked about. And finally, the problem of, well, are there any proprietary relations here in custody? You heard about some huge insolvencies. The Cryptopia insolvency is so huge that the administrators set up a website to deal with the claims. But there are also other problems. For instance, in a recent case in Singapore, and now looking at my colleague, yes, the Netherlands Commercial Court said no ownership in data. I think they're plainly wrong. And we should not forget that it's not the Netherlands Supreme Court. And the same happened in Singapore. The Singapore Commercial Court said no, but now the ordinary courts in Singapore say yes. I'll give you just briefly the facts to build a bridge to what my predecessor said. A company paid its employees in fiat currency and in crypto assets. And the person responsible for the payment of the crypto assets, so the transfer into the addresses, the internet addresses of the beneficiaries, decided that it would be much better if the money went to her personally. So fraud. The company discovered it, found out where basically the crypto assets were, because that is already a problem to begin with, and then wanted their crypto assets back from their employee. The assets were in custodial wallets and a private wallet. And then the Singapore court decided that all crypto assets were, in the terminology of English law, choses in action, therefore property, and therefore trust law applied, and under English and Singapore trust law, it meant that the employee held them on trust for the employer. That was quite an interesting solution. So what we see happening is a development that moved from, in the beginning, well, we have contracts about data. Property law has nothing to do with that. My question at the time was, but if the contract is about data, you're transferring something, right? Because you pay for it. So there is an object. What is that object? And obviously there is a right to that object, because if it's just that you can use my data and now they are your data and no one cares to whom the data belong, why would you pay money for data? Why? And that is how my question started. So the next part of the morning, no, I'm joking. I will take you briefly through these points. I can only do it briefly. You will understand, and I hope you will forgive me, but it will give you an impression. So I'll say a little bit about classical property law, because I have to. We move to, I think, the heartbeat of property law, which is the numerus clausus principle. We have to look at transparency, specificity, because no specificity, no segregation, right? Commingling, right? And how to create specificity when it comes to data, because data can be copied forever and forever and forever. How can you say that data are yours if they are everywhere and nowhere? So we need a changing perspective on property law. So let me take you briefly through this. Now, our 19th century property law is fairly dogmatic. It was written in stone. And then you get decisions as from our Netherlands Commercial Court. Data are not physical. You can only own something physical, so you cannot own data. That is a fairly dogmatic, unworkable, unacceptable answer. I'm really critical of that decision. The law is becoming transnational. It's becoming transgenerational. We are worried about our climate. We are worried about future generations. But is it compatible with the digital reality? Now, what I call property law, because we're all doing this in English, and by using English, we cannot avoid using the English legal language, which is inherently ambivalent and unclear. Apologies. Property can mean anything. Ownership can mean anything. A civil lawyer will then say, what is property? What is ownership? So I have to be careful when I use English. Now, generally speaking, from a comparative viewpoint, property law is about legal relations between a subject and a relevant and considerable group of other subjects regarding an object. And all of these are now to be questioned. I will come to that. Even subjects, but particularly objects. Now first, classical property law, property in the real world. There we have to be extremely careful from a comparative viewpoint. We have the distinction between civil law and common law. I already hinted at that. In the civil law, we say ownership, and that's the most complete right over a thing, and then we can debate what a thing is. For the common law, you have to focus on the object. Are you talking about land? Are you talking about movables? Claims. In land, it's estates. Movables, it's title. And title is relative, it's not ownership, and go on. You would call it ownership, but it's not, right? I'm challenging you a little bit. So what do we mean? What we do know, however, is that in spite of the differences between the various legal systems, they do have a shared legal framework. There are leading principles, like numerus clausus and transparency and hierarchy. I'll say more about numerus clausus and transparency, hierarchy, because you talk about rights against the world, and these rights can get into conflict with one another, so you need priority rules. What you also see generally is that whatever the legal system, whether it's civil, common, or mixed, it will have one type of right which gives you the most power over a thing, and then you have other rights against the world that give you less power. Like the holder of a right of mortgage is not the same as the person owning a building. So let's have a look at the numerous clauses. And I have to do that before I can get to questions about data. Now, the numerous clauses has explicit and implicit aspects. Explicit is, and that is the way we traditionally approach it, which the way you will find it generally in German legal literature, that the number and content of property rights is limited. So number and content. That's substance. There is also procedure there. Procedure in that the numerous clauses also says how does a property right come into existence? How do you transfer it? How does it extinguish? How does it terminate? But hidden under that, implicitly, is that the numerous clauses also says something about subject and object. The best example, I already in fact gave it, can be found in the German and the Dutch civil code, where ownership is the most complete right over a thing. So the right, ownership, is qualified by the object, the thing. The thing must be physical. If it's non-physical, the right of ownership does not apply. Question, which other right then will apply? So the object is part of the definition of the right. It qualifies the right. And we are talking about data. So is data an object that fits under ownership? Subject as well. Traditionally, we say subjects are natural and legal persons, but can an autonomously running AI-driven computer system also be a legal subject? Until now, the answer generally in case law is no. In intellectual property law, the answer is no. But the moment, I can predict you that, the moment will come that the answer will be yes. That your counterparty is a machine, a system, scaring. So from that perspective, let's have a look at data. Now, data is, it can be copied forever. So how can you create a property right in something that you can copy forever? Why is Bitcoin money? Although Bitcoin is nothing more than, strictly speaking, an electronic document with data saying, I am money. But why do we pay so much for it? How come? The problem here is the principle of transparency. That is that for having property rights, the object must be specific and it must be visible. You must be able to see it. There must be publicity somehow. Now, this specificity can be ex ante or ex post. You can say from the beginning it's clear, okay, this is my clicker, that's it. We know. But we also accept that you can decide which the objects of property law are from hindsight, afterwards, in insolvency situations. Let's say when you pledge claims, it may be sufficient if with hindsight you can say, okay, looking at hindsight, with hindsight, looking at what happened, these are the claims that were pledged. Okay. For publicity, we generally look at possession and registration. And how do you look at that from the perspective of data? Can you possess data? But again, for possession, you need specificity. You cannot say, I possess data. That's a senseless statement. So you need control and access. And exactly the term control is more and more used to explain which sort of power you must have over the data before we can start talking about any proprietary interest in data. And control includes access. But access is not enough. It's not enough to have the data on your screen. You must be able to do something with those data. So what sort of assets do we have? And why can they be fitted into the principles of numerous clauses and specificity? Or not? We have raw data, the outcome of sensorization, right? We are followed through sensors everywhere. When you are, I explained it last week to my students, I said the university knows exactly where you are in their buildings because you all use Wi-Fi. Right? They can trace you. It's really easy. The university collects lots of raw data about us. There are other examples, like cameras that watch traffic flows. So who owns those data if they are not specific? How do you make them specific? So that's a main problem with the Internet of Things. Like when you have a doorbell with video and audio, to whom belong the data as to who is ringing the doorbell? Is it you? Is it the company that manages the data stream? How does that go? So these are non-specific data, which we must make specific. The actual specific data which we already have are cryptocurrencies because of the blockchain network. Because what blockchain does is it creates unique copies. So there were still many copies, but this one copy is the one you can deal in, because if you want to sell your Bitcoin for a second time, the system will decline and say, no, you don't have it. You can say, yes, but I have a copy on my laptop. That's irrelevant. The system said you transferred it once, that's it, game over. So you have a unique copy. The same will be the case with the central bank digital currencies that we talked about. I will not discuss any privacy concerns here, because these currencies can be programmed. And there is a worry among privacy lawyers that it could be programmed in such a way that if you want to pay a butcher for buying meat, the currency will simply say, no, you're not supposed to eat meat because that's not good for the climate. Right? So there's a serious privacy problem there, but still. We have tokenization, the issuing of tokens representing value. Right? A token can represent a right, it can represent a physical object. And tokens are specific enough because they run on a blockchain. Wallets. We will all get a wallet. But the wallet itself is also data. But it's specific because the proposal for a European digital identity wallet, and that development is very far. So we will all get an EU wallet for storage of cryptocurrencies, copies of notarial deeds, health data will be stored there as well. Question, wallet on your phone, wallet on a server, which server? Privacy, what about privacy? Okay, questions. Social media accounts, they're specific because they're linked to a person. And collections on a cloud server, so your pictures and so on. So what we see is that as soon as data become specific, we can deal with them. We can talk about proprietary interests. We can talk about inheritance. We can talk about seizure, getting them. I was involved in the drafting of an international code of principles for seizure of digital assets, drafted by the International Union of Judicial Enforcement Officers. And we encountered the following problems. First, you have to know that there are digital assets, tracing. You have to be able to find them and get access. And then you must be able to transfer them. Right? And as long as what you find is unspecific, you still can do nothing as a judicial enforcement officer. And I'm not even talking about problems as to clients refusing to give you the private key, saying, I lost it. The tax question then, by the way, is, in case you inherit, we discussed that in the group but we left it, in case you inherit Bitcoins, but you tell the tax authorities that you do not have the private key, do you still have to pay succession tax over the value? What will tax authorities do? Our guess is they will give you a diabolic burden of proof, saying, prove to us that you do not have the private key. How do you do that? A negative proof. Anyway, there's quite a lot going on. The problems we are talking about are really, from a property viewpoint, but I think generally also the tip of the iceberg. We are trying to solve problems, but we don't know what is coming, and I think there's quite a lot coming. The problem with legal qualifications is, well, if you want to legislate in the area of property law, you must have sovereignty. Do we have sovereignty over data? The EU claims sovereignty over data, following the United States, following Russia, following the United Kingdom, China, and other countries. They have no option. So when you claim sovereignty, you can decide on who owns certain property rights, so you can attribute and distribute those rights. And that is what the European Union is doing in the Data Act, in fact. So the data coming out of the Internet of Things. But what we see is that in this area, private-public law mixes. We have grey areas between contract, tort, and property, because contractual arrangements might have an impact on what the object of the property right is. So, how to solve this? How to solve the problem of data that can be copied? Why do we accept that certain data have value and other data are a matter, particularly for privacy law? Well, what we do is we look for data clusters. And we can do it in a classical way, a more static way, by saying one copy of the data, of a set of data, we consider to be the only relevant copy. All the others are just copies. And we don't do anything with them. That is what happens in the Bitcoin or in blockchain networks. This is what happens with NFTs, right? Non-fungible tokens. You can have a more dynamic approach. You say if there are more copies, or if several people have access to the same copy, then it means that your object is changing, and this has an impact on the right, because that is what I told you in the beginning. What the right is depends on the object. And if the object is dynamic, the right becomes dynamic. So what a property right then is no longer what we traditionally would call a property right. So, we need to rethink our 19th century conception of ownership in light of the principle that we have. I'm not saying that we should just go ahead and have a revolution. Revolutions always build on what was going on before. And usually revolutions after the revolution suddenly become quite conservative. Like under French law, where they abolished the feudal system, and then in the 1830s, the Supreme Court ruled that the old feudal property rights had survived the French Civil Code. It's really, really interesting. So we have to reconsider the existing principles. They work, they help us structure the way we can regulate. But we must realize data, and we live in a web of data, that is a dynamic world. It's not static. So the rights that we talk about in some way have to reflect that dynamic reality. Perhaps different degrees of ownership, don't even call it ownership. In my writings I defended that data ownership simply is not there. What we are talking about is management of data, management rights. Right? So to avoid that we use the term data ownership or data property, but the thing is the terms are used so they are unavoidable. But by using the term, people think that you talk about traditional ownership, which is not the case. So, to summarize, I looked particularly at data from the perspective of the numerus clausus principle and the principle of transparency, because if you want to have an object of rights, particular object of property rights, the object must be clear, it must be definable. How to do that? That's what we also looked at briefly. And I think we should reconceptualize what we mean by ownership. It sounds very theoretical, but I think that's exactly what is going on. What's going on in the work of the ULC in the United States, what's going on within UNIDROIT, what you see at a national level. And basically, I think this is where we stand at the moment. I hope I was clear, although it was brief and it was fast, but it was a pleasure talking to you. Thank you.